Good morning, everyone, and thank you for joining us today. Today we have Maria Hurd and Anne-Marie Luciano, both partners in the State Attorney General Group at the national law firm Cozen O'Connor. Today we will be bringing to you, our membership, a program that will cover many important topics to inform and help companies determine whether their company is at risk of a state attorney general investigation. If anyone has any questions, we just ask that you please place it in the chat. And at the end, if we have some time, we will do a Q&A. And if not, then both Maria and Anne-Marie will gladly answer those questions at the through email. As a friendly reminder, we'll be recording the program and then sharing it with you all later today. Maria and Anne-Marie, thank you again for your time this morning. We can go ahead and get started.
Thank you so much, Kathy. Yes, I'm Maria Hurd, and I'm very pleased to be here with my partner, Anne-Marie Luciano. I have been involved in the CINJ for probably the last couple of years, working on various issues, and it's been a wonderful forum for coordination. And the whole time I've been thinking, what's some way I could give back? And this is one of those conversations that I'm hoping is a give back conversation that helps the members who are here today or are going to watch the video just learn a little bit more about how AGs operate across the country. Anne-Marie and I have a national practice. We've worked together for a very long time. What we do is we do other things. We do federal work too and litigation work, and we represent entities that find themselves targets of AG inquiries and AG litigation. So we're going to share some of our thoughts today. I will mention that one of us is a native of New Jersey. The other is a native of New York. I am not going to tell you which. Perhaps you already know by listening to my voice which of the two I am, but maybe it'll be a little quiz we can have at the end. Which one of us is from New Jersey? Which one of us is from New York? Even though we both live in the DC area now. And that is where our practice, our national practice, sits. So Anne-Marie's background is a litigator. She has had some wonderful high-profile cases. She could tell some great stories. She has very unique abilities in antitrust and data breach. If your entity has suffered a data breach, Anne-Marie can walk you through how you notify the state and all the things that could potentially happen because of those issues. I focus a lot on consumer protection, which you'll hear covers a very broad umbrella of things. I also do regulations, and I do things that touch on in the environment, which is what I've been working with CINJ on. Here's a disclaimer. These are our views. They're not the views of CINJ. They're not the views of our clients. They're not the views of our firm. So with that, let's get into it. Let's go to the next slide, and we'll start with what we call State AG 101. So the AG is the state's chief legal officer and is an independent constitutional officer. The role of the AG will vary by jurisdiction, but just very generally, the things that the AG does is provide legal advice to the governor, the legislature, and state agencies. Now, this legislature piece, sometimes people forget. In some states, the AG can actually propose legislation. So if you're doing a legislative campaign, you need to consider the AG. Even if they cannot propose legislation, the AG will often weigh in on that legislation, or the agency or the legislators will ask the AG to vet the legislation. So always keep them in mind. They are, the AGs, of course, are the defense attorneys for the state. But what we're going to focus on today is a role that the AGs have that's important to all of you. And that is the AG as a plaintiff's attorney. It's hard to think of them that way, but they are a unique plaintiff's attorney. They bring enforcement actions and other affirmative litigation against businesses, individuals, and organizations. And what makes the AG unique in this area is that the AG has the power to do a pre-litigation investigation. You don't get to investigate them, they get to investigate you. And then they decide, is there there that they want to pursue? And we're going to talk a little bit more as we move on about this investigatory power. It is statutory, it has unique procedures, and requires a unique focus. So let's switch to the next slide. On top of that, of course, you have politics. And in the vast majority of states, the AG is elected. So they have political motivations. But even where the AG is appointed, and New Jersey is a state where the AG is appointed by the governor and then confirmed by the Senate, the state Senate, they have political motivations. They have a policy agenda. They have things that the elected officials that appointed them want to be on the agenda. So you always have to think about that political piece and those policy objectives of this unique plaintiff, the AG. Matt Platkin, who is the AG of New Jersey, he was appointed in 2022. His term ends in 2026. Right now, we have 27 Republican AGs, 24 Democratic AGs, but this year, 2024, there are going to be 10 elections. I'm not going to name all the states now. They'll be in the handout that we give you later, but one of them locally is Pennsylvania. And the current AG, she has said she's not going to run. So I think at this point, maybe it's gone up, but last time I checked, there were about 8 candidates throwing their hat in the ring to be considered for the next Pennsylvania AG. So I'm now going to hand it to Anne Marie because I've introduced the concept of the unique power of the AG, the political aspect of the AGs. And now Anne Marie is going to tell you about how the AGs take coordinated action.
Thanks, Maria. Yeah, there's a number of ways that AGs coordinate, and it's important to understand how they coordinate because understanding how they coordinate can reveal when you might be aware of exposure to your business. So the first way that they've been doing for decades is simply sharing information about trends in consumer complaints. So there's a complaint database. This complaint database, they also share not only among themselves, but also with their federal FTC counterparts. There's tracking of complaints by topic, and they look at trends. And so some states may have more complaints about a particular issue, but generally speaking, there may be a national trend. And so when they see a national trend, they'll start coordinating and talking about what they're seeing in their states and maybe whether they should take coordinated action to investigate the companies involved. So that's one way. And we always tell our clients that complaints are the canary in the coal mine. So companies that do not have a robust process to track consumer complaints, where complaints may get lost, consumers, email a box that may not be maintained or checked. There's not a formal process of how to respond in a timely fashion. That increases the likelihood that that business would be subjected to some type of investigation. And we'll speak more later about when you do get that request for information, what you should do. So there's the information sharing on complaints. There's also enforcement cases that they bring together in multi-state investigations and litigation. And so when they do believe that there's a violation of consumer protection laws, for example, or data privacy laws or antitrust laws, they will coordinate to seek information from companies. Sometimes it could be a lengthy process of providing documents and information. And once they do that, depending on what they see, they may say, okay, we believe there's a violation of law here. We're either going to sue or we ask that you settle in some type of settlement agreement with a potential payment to consumers. The number of settlements has dramatically skyrocketed over the past couple decades. So just by way of example, in the year 2000, there was a total of $522 million in multi-state settlements. In 2020, 20 years later, it was up to $3.3 billion. So the amount at stake has skyrocketed, and the AGs also are able to coordinate more effectively through their various national organizations. So there's a Democratic organization called DAGA, there's a Republican organization called RAGA. On some issues, it's partisan, and Republicans may investigate certain issues where Democrats may investigate others. But there's many bipartisan investigations. We deal with many 50-state, multi-state investigations. In addition to that, there's the National Association of Attorneys General, a national organization where AGs will get together. There's working groups by topic, and they will proceed to either announce comment letters, amicus briefs, or supporting legislation, and also coordinating on multi-state actions. The meetings of the national organizations and the Democrat and Republican organizations also offer opportunities for businesses to find out what the issues are that AGs are focusing on and prioritizing. So Maria and I attend these meetings, and it's really insightful to hear in the public sessions what the trends are. For example, last year, they were focusing a lot on algorithms and AI and data and privacy issues. And so you get to hear what it is that the AGs are seeing, what they're focusing on, and how they view that through the prism of their consumer protection laws and their theories, their legal theories. They will engage with you to explain their legal theories as to why they believe a particular practice is a violation of law. It presents opportunities for business to attend some of these meetings. If it is a business that interacts with consumers and there's a new practice that is at issue, to inform the staff about the practice and the safety measures for the consumers. So, because sometimes, as we well know, the government doesn't always keep up with technology or the most recent trends. And so sometimes a failure to understand something means that there's a view that it must be unlawful. And so attending these meetings helps to disabuse them of that notion. In addition to working with each other, the state AGs also work and coordinate with their federal counterparts. There's a variety of ways that they do this. AGs enjoy specific statutory federal power in a variety of different ways. And oftentimes, if there's a consumer protection issue that is a national in scope, the FTC, for example, might get involved. And so you will see actions where you have 50 states or maybe 23 states and the FTC both investigating, coordinating. The FTC and the AGs are on the same calls with us. They're coordinating, getting the same documents, information, having the same meetings to really analyze an issue and see if there's a violation of law. Obviously, they each as separate sovereigns have different priorities and interests, but we have seen a lot more coordination after the big Supreme Court decision in AMG Capital, which is, many of you probably know, there's a lot been written about it, basically limited the FTC's power to get consumer redress and remedies under Section 13. The FTC is not without total power for redress. They can also do so under Section 19. There could be a whole other webinar about the FTC's powers. But because of that, the FTC has, really focused on how they can leverage collaboration with the AGs and consumer protection investigations. And there was a statute passed, the FTC Collaboration Act of 2021. And AGs submitted comments about ways that they could coordinate with the FTC following AMG Capital to use the benefit of the FTC's experience. The FTC has a lot of experts and expertise. Some states have low, budgets. And so how can they work together despite the Supreme Court's decision? And we've really seen in our practice and with our clients, the FTC taking a bigger role and coordinating much more with AGs out of necessity, really. So next, I think what we'll do is we'll talk about some of the trends that we've seen in enforcement. But again, the main takeaway with respect to thinking about exposure for a business is not only state specific exposure, but how the particular issue could overlap with federal law, and whether, for example, the FTC may be interested because there's a particular issue with respect to Fair Debt Collection Practices Act, or with respect to, solicitations by phone. If it's a telecom company, it could be an issue with respect to children's privacy. Many privacy issues the FTC gets involved in. We've seen the FTC involved in data breach and data privacy issues. And then, of course, antitrust, which we'll talk about later in the program. Antitrust is a big area where we see coordination between the states and their federal counterparts to review mergers, to challenge mergers. There are mergers that we've worked on where the DOJ and the FTC have no problem with the merger on a national basis, but there's a particular state impact, and the state AG is the holdup on that. So one really needs to think broadly about how AGs and the feds coordinate and how that can impact your business, whether it be through a merger, a combination, or a practice with respect to a new data issue. So now I'll turn it over to Maria to talk about some of the enforcement trends by topic that we've been seeing in our practice.
Thanks, Anne Maria. That was great. And I loved your takeaway. And it just made me think of some of the matters that we work on and we're currently working on. And again, just to highlight the point, another big reason why you have to try to coordinate what could be two parallel federal and state discussions is that you don't want to end up with injunctive relief or requirements that are going to conflict, where your business operations are not going to be able to meet both requirements. And we bring the FTC, for example, and the group of states together to talk and bring them. They talk to each other. We talk to them. We talk as a group to try to make sure that our client, the business, can continue to operate going forward and can meet the requirements of both federal and state entities. So yes, now we're going to talk about some enforcement trends, and we're going to get a little bit into these topics. Of course, priorities can always change. When a new AG takes office, and again, as I said, there's going to be 10 elections this year, that AG will come in with their own agenda and their own focus, and things could shift. Also, if there's a newsworthy event, things could just shift for them. Just take the pandemic, for example. I do not think if in 2019 you asked any AG's office what their priorities were going to be in 2020, they would have said price gouging for PPE for consumers. It was on no one's radar, but then suddenly that became a very high priority in 2020. Every office, however, is always focused on consumer protection. And this, I'm going to talk about this next in a little bit more detail, and it demonstrates this pre-litigation investigation power that I mentioned at the beginning. So Anne Marie, if you'll switch to the next slide, and we'll dive into this consumer tech protection. Anne Marie already mentioned complaints, and some of you may have received from state offices inquiry letters where an individual consumer has filed a complaint with them and said, for example, I signed up with this service, or I hired this contractor, I bought this product and they promised me X, but I didn't get X, or I was overcharged, or whatever the issue is. And they will send you a letter that says, please investigate this yourself and resolve it, and let us know how you resolve it. Those are very day-to-day consumer protection work of these offices. When I talk about a pre-litigation investigation, I am not talking about those. Those are very important, and those are part of what Anne Marie said are things you need to track and look at to see where your risks are. Those are all good indicators to you if you're getting repeated complaints about the same issue, that you should address it and you should talk to your employees. You should adjust your procedures. But what could happen is if an AG's office sees, we've gotten 10 complaints on the same topic about this particular business, they will then say, I think I need to look into this. They will serve you with a subpoena. Sometimes they're called civil investigative demands. Sometimes they'll be less formal and they'll just be inquiry letters. That is what we're talking about here. And the AG can ask for documents. They can ask for written responses, and they could also interview your employees. I'm not going to use the word deposition. They sometimes use the word deposition. We have, I could talk all day about that and whether or not they're actually getting usable testimony from these interviews, but they have that power. Okay, so what is under the Consumer Protection Act? Every state has a Consumer Protection Act. Sometimes it's called a UDAP statute, unfair and deceptive acts and practices that are prohibited. What are these practices? You're probably asking. I want you to think about everything your business does that is consumer facing or that impacts consumers. How are your products labeled? How do you market your services or your products? What's your advertising look like? What is the price that you charge and advertise? Are you clear about what you're charging? What about add-on fees? Do you have add-on fees that show up on your invoice? What's your delivery like? When you send service people or technicians to a consumer's home, what are they representing? How are they delivering the services? What happens? Do you have a consumer service center, a call center that people can call into? What are they saying to consumers? Do you have subscription services? Are they auto renewed? AGs, that's a topic they always look at. They don't like auto renewals. How easy is it to cancel your service or to return your product? Is your product safe? Is your product effective? The list goes on and on. It is a very large umbrella, according to the AGs. Also, what is unfair and deceptive, they look at very broadly. It is not just a affirmative, intentional lie. There are many different types of acts and practices that they will label deceptive or unfair. Okay.
And if I could just jump in on that
Go ahead,
point, to tie in something, what Maria said is so important right now in particular, because what we're hearing at these AG conferences is that there's a huge focus on what is not directly unfair, but what is subtly unfair by the process by which the consumer needs to make a decision. So if the website makes it super easy to sign up for $5.99 a month or something, but makes it really, there's a completely different way to cancel, or it's hidden, or it's multi-steps, that is considered to be unlawful. It's deceptive. But it's beyond that. There's been discussions about 5 left. Is it really true that there's 5 left, or is that a way to get someone to buy something? 1 minute, a countdown clock, 1 minute left to make this purchase at this price. Is that really true? And so there's really been a lot of thought about how some of the things that exist now on online purchasing, how those practices, they're obviously intended to get someone to make the purchase or to spend more time on the website. Do any of those cross the line into unlawful activity? And it's really something that they're struggling with. I don't think they're struggling with it enough. I think they think the line is much closer than it actually is. But it's just something to be thoughtful about when designing websites or engaging with the consumer. How would the consumer react? And then how would a regulator perceive this? Does it cross the line into, this is really getting a little bit too difficult, too cute for the consumer to make an informed choice?
Mm-hmm. Yeah, thanks, Anne Marie. That is helpful. So what happens when the investigation is complete? You've given them information. Maybe they've interviewed somebody. They've talked to your attorneys. the AG could determine not to proceed any further. They could be satisfied. Okay, there really wasn't anything here, and close the file. That would be a fabulous outcome. Congratulations. But often what they do is say, okay, you know what? We see what's going on here. We think you could change your business practices a little bit. And we want to negotiate a settlement with you. So they will propose a settlement in order to resolve this, or they could go to litigation. And if you look at, you really have to look at each Consumer Protection Act, whatever Protection Act that AG is invoking, or other statute they're invoking, to see what the standards of proof are, what the exemptions are, and those sorts of things. But they could ask for some very unique relief, equitable relief, so injunctive relief. This is what you may do. This is what you may not do in your business practices. They could seek restitution payments to or on behalf of consumers. They also have the power to seek civil penalties or fines, and those could build up and build up. If you look and see the civil penalties and you see it says $5,000 per violation or $10,000 per violation, you may think $10,000 isn't that much money per violation. AGs are very aggressive in how they interpret that per violation language. They may say every single consumer that saw that ad, that each one of those is a violation. Every time you charge that price, it was a violation. And when you take a $5,000 fine and you multiply it by 1,000 consumers, you can see where those civil penalties start to get higher and higher and higher. Settlements provide obviously more flexibility, which is why often the AG's offices try to reach a settlement with you. And from your point of view, you want to try to come to a win-win. There may be opportunities in those settlement discussions to use some of your existing business operations or leverage things that you had in a planning stage to satisfy the state, to show that you're moving in the direction they want you to move. So, always look for win-wins in those settlement opportunities. On the next slide, this goes into a lot of depth. And if people, lawyers on here want to read cases and look at statutes, but basically what I'm saying here is you need to look at the state's specific UDAP statute, at their standards of proof and exemptions. You may be an industry that's exempt. So look there first. Look and see if you feel like the subpoena is completely out of line, overbroad, and you can't narrow it down by talking with the AG's office. There is a mechanism to challenge it in court. There's usually very, very short time frame to do that. So you always need to check that. The thing you need to be aware of is the state very often does not have to prove any bad intent. They don't need to prove that you intended to deceive or intended for there to be some unfairness to the consumer. In addition, many states, they don't have to prove any reliance or harm to any actual consumer. What they will show is that a reasonable consumer would have been confused, would have been deceived. So that is something that kind of leans in the state's favor in these types of litigations. Looking specifically at New Jersey, the New Jersey Consumer Fraud Act, the New Jersey AG is not obligated to demonstrate that consumers suffered any actual harm in order for them to get the remedies that they want in litigation. So it's very important to understand the standard of proof that the AG has. What types of issues is the New Jersey AG's office looking at right now? Disclosures, consumer finance, Credit card surcharges without disclosures was a recent area that they've been active in. Fair and transparent pricing is the item when they scanned it at the register a different price than what was shown on the shelves or shown in an advertisement. Pricing is always an issue for all AGs, but the New Jersey AG has been focusing on that too. New Jersey looks at antitrust issues, which Anne-Marie is going to cover later, and data privacy, which we've already mentioned. I know from personal experience that the New Jersey Consumer Protection Division definitely has shown interest in data privacy, data breaches. And this crosses over into the environmental area, the disposal of electronics that has data on it. So you've got an environmental issue by, let's say, throwing a credit card scanner into a regular dumpster because it shouldn't go there. But did you wipe it, clean it of the PII, the personal information that's on there? If you didn't, you have a privacy issue too. So since we keep talking about privacy and how important it is, and all of you hold consumer data and employee data, Anne-Marie, why don't you talk a bit more about data privacy?
Absolutely. Yeah, this has been, I feel like, the biggest trend in the past 5 to 10 years, with AGs focusing on not just data breaches and data security events, ransomware attacks, but also how does a company tell people what it does with their information, and does that match in practice? Not only clear, blatant violations where they say we don't disclose your data or sell it to third parties, and they do, but also other things where, for example, the company or in the healthcare industry collects certain data and they don't have sufficient security measures so that the cookies and some of the information about the healthcare data is sent to the Facebooks or others. And then they can use that. They can say, wow, they have a lot of patients that are taking, HIV medications or these medications for depression. And so it's really all about understanding the risks with respect to holding, sending, or maintaining data. And there's a few primary sources of the AG's power in this regard. The first is there's data breach protection laws. So there's data breach laws that basically say, define what a breach is, unauthorized access of information, define what PII is. Every state's a little bit different, but there's, generally speaking, a set of elements that are considered PII in every state. Some states have some extra elements like biometric information and others. And so if there's a data breach or data security event, AGs will use that power to investigate, as well as their UDAP consumer protection power. And we find, because we handle a lot of these, Maria and I work on a lot of these multi-state investigations on data breach and data security incidents, we find AGs rely primarily on their broad consumer protection power. They don't need to prove that you gave notice 60 days instead of 30 days, or that you didn't provide proper notice to all the consumers or to all the states. They only need to say, this data breach happened, and you had an unfair and unreasonable data security program because you didn't have the best standards and practices in this regard. Or what you represented to the public on your website is, we take security to be of our utmost concern and priority. We've invested heavily in security over the past 5 years. I had a case where they pulled a quote that the CEO made on a TV show about, we highly regard and focus on data security investment. And then they got in the documents the actual investment and said, see, it's a consumer protection violation to tell people you care about security, but not have your investments match that up. So they really like that broad power, and looking at what representations are made about how information is used, reused, or stored. So the sources are data protection laws, consumer protection laws, and now these new and increasing number, now 13, data privacy laws. And the data privacy laws relate to not only what information should be protected, but also what consumer rights they have to either request that certain information be deleted, that they provide access, or they get some type of inventory of the information being held. And so now AGs are starting to enforce against those laws, arguing that a company did not respond to consumers' requests for deletion, for example, under like the California CCPA. And the issue with data privacy is that it's such a patchwork, and there's not, as everyone knows, a federal counterpart. So there's no federal standard of what is an unreasonable practice or what is an unreasonable response to a cybersecurity incident. And so we see different offices taking the lead. Certain offices make it a priority to investigate data breach and data privacy issues. And so we're really seeing that. And that's why it's so important to know and keep abreast of what's happening in the state and what the state's enforcement history has been. Because when you have a new product that might involve consumers providing new information, that's something that they're going to look at. So, as I had mentioned, we now have 13 states that have enacted comprehensive privacy laws. California's CCPA was the first. And there's typically thresholds about the number of consumers that you hold data for to see whether or not you're triggered. So it's a very state-specific inquiry to see whether or not your business has to comply with a particular state's privacy law. It's many factors. There's exceptions and exemptions based on whether you're like a bank, or sometimes HIPAA exemptions, for example. And New Jersey, as Maria mentioned, just very recently Governor Murphy signed on January 16th, a bill that will it became effective January 16th. And it's very similar, this privacy law, to Colorado and California's laws. And again, it's rulemaking authority to the AG. And what that means is the AG's office is going to have the opportunity to really explain how it's going to interpret that privacy law. And we've seen some interpretations that we feel in other states cross the line into what is really considered PII. One of the issues, for example, is if you de-identify information. So Anne-Marie Luciano, this is my address, this is my personal information, and there's a de-identification. If that de-identification can be re-identified in an easily accessible way, it may not truly be considered de-identified. We talk about anonymized data. So there's a lot of different issues coming up as AGs start interpreting and providing guidance about their new privacy laws. And companies really need to focus on the state-specific laws and the impact on them and how they handle consumer data. There has also been a push to evaluate additional categories of information that may be considered extra PII or sensitive PII. And for example, in the New Jersey law, there are certain categories of truly sensitive information like race information, other information that you would need the consumer's explicit consent to process or use. And so that's another new layer that's being added on in the state privacy realm for businesses to address.
Yeah, Anne-Marie, it's all very important, and all of you need to look at that. I'm looking at the clock, and I want to make sure we get through these next topics and get to the end where we give you some, okay, well, what are your tips for us? I mean, we've been giving tips throughout, but we want to get to that. Antitrust is not new, but it has gained momentum there. We are at an all-time high in federal and state coordination. The explosion of focus on AI and big data comes into play, if you could believe it, in this area. They've been talking about dataopolies, which is a concern that there would be a concentration of big data in the hands of just a few large companies, and that will hurt competition and be a barrier for smaller companies. You may actually be one of those smaller companies that feels this way. And sometimes we talk about the AGs as someone who is targeting you and you are on opposite sides of the table. but sometimes you can be a resource to them, and you can actually align on issues. This may be one of those issues if you're a smaller company and you find yourself having trouble competing with companies that are using AI and big data. Anne-Marie, do you want to just quickly touch
I'll
on
just quickly
other
add.
areas?
Yeah, I'll just quickly add to that big data and AI question that we've seen in the antitrust space. AG is now looking into whether the use of AI tools, algorithms could amount to an antitrust price fixing conspiracy. So for example, the DC AG's office recently sued RealPage, which is a provider of a revenue management software tool. And the allegation is that the property owners and property managers who use this software, that they either allegedly provide non-confidential information or receive non-confidential information from other competitors. And it's the tool itself that combines this non-confidential information and shares it that may amount to an unlawful antitrust conspiracy. And there's other algorithm cases, also like private litigation, where these theories are being made. And it'll be interesting to see how this pans out, because I feel like this is a new area of trying to see whether the antitrust laws would view any conduct that's conducted through an algorithm as potentially an unlawful antitrust agreement among competitors, depending on who has access to that algorithm. So it's very interesting space to be watching and following.
Yeah, and I also, I'm
ahead.
sorry, Anne-Marie, I just wanted to put
Yeah.
an underline on the healthcare industry too. And in the antitrust area, but it's fine to switch to this slide. But first, talking about antitrust, healthcare is one of these areas where maybe the feds would not be as interested as your state AG would be when you have these mergers and consolidations of physician groups or hospitals. The national picture may not be impacted, but a state AG may see a local impact. So you may need to engage with the AG's office if you're trying to get approval for one of those types of healthcare mergers. And Anne-Marie, you want to touch on some other healthcare related topics?
Yeah, so just quickly, AGs are very active in the healthcare space in a variety of different ways. You know, oftentimes we think about the federal laws that guide the requirements in the healthcare space, but AGs are not hindered by that. And because of their consumer protection authority, are able to go after companies who don't properly label their products, make improper representations that are not substantiated about their healthcare products. AGs also go after companies who fail to comply, for example, with the Food, Drug, and Cosmetic Act. We know that AGs have been very active in the opioid space and even going all the way down the chain against retailers, distributors, and others. The AGs more recently have been focusing on whether or not pricing has been fair and transparent, and going after any type of surprise billing practices. So the typical one, for example, that the Massachusetts AG went after a couple of years ago was failing to adequately disclose that certain services were out of network, or to collect high charges from patients. So the things that have been existing in the healthcare realm for many years about out of network and services denied, now AGs are starting to view those in the prism of, is this a consumer protection violation? Is it unlawful? Is it unfair to not properly disclose what is in and out of network? Price gouging, as Maria had mentioned previously, is something that they continue to look at. Typically, though, that's only in a national or a natural disaster or some type of emergency situation. Medicaid fraud is always something that we see states going after to get recoveries. And then finally, the new area is we've seen a lot in the telehealth, digital services, healthcare space. Some AGs initially were concerned about telehealth to ensure that during the pandemic, consumers were protected from a privacy perspective and state licensing perspective. And then we saw some, relaxing of regulations, but AGs continue to look into telehealth practices and examples where consumers are being misled about the credentials of those performing telehealth, where some fly-by-night companies are just, creating these services to write prescriptions without the proper authority, et cetera. So AGs have been very active in that space as well. Next, I'll just quickly touch on some environmental issues, which AGs have been very active in for many, many decades. The new area that many of you are, I'm sure, familiar with is PFAS, which is short for per and polyfluorinated substances. Basically, these are chemicals that are used typically to protect things from heat, from oil, from grease, from water. So it's like a coating. And these substances are made with chemicals that are called forever chemicals that may cause cancer and other health problems. So there's been a lot of litigation about this. And there's been a lot of discussion about the negative health effects. And I know that yesterday, the New Jersey DEP commissioner said that it's a really big long-term management concern for remediation sites. And of course, there's a huge impact on the waterways. And we see, because these substances are used for firefighting, for heat protection, a lot of states now in New Jersey just passed a bill that prohibits firefighting materials being used with PFAS substances. And these restrictions will be phased in basically over time. It's a big overhaul of like what firefighters have been doing, because obviously the concern was always previously preventing firefighters from getting injured. And now they've unfortunately learned that some of these firefighters have been exposed to chemicals that are harmful. So there's states that have been leading lawsuits against PFAS manufacturers for violating state environmental laws, as well as consumer protection laws. There were 13 AG lawsuits initiated just last year. So now there's a total of 27. So this is a big, big space to keep on watching. And AGs are very, very concerned. Their consumers are concerned about the effects of these substances that for so long were not known. Now, Maria, I'll turn it over to you about solid waste, hazardous waste.
One of my favorite topics. When I became a lawyer, I never thought I'd spend so much time talking about landfills and dumpsters. A lot of the people on this call know that this is an area of concern in New Jersey. They spend a lot of effort, have a infrastructure for the regulation of solid waste, coming at it from many different angles, regulating who can collect, transport, and dispose of solid waste. The laws were created to address the influence of organized crime in the solid waste industry, a very good goal. And then the laws developed over time to also protect human health and the environment. There are actions that some of you know where they're trying to regulate well beyond those entities who are actually disposing, transporting that waste. I am involved in that. And for any of you that are involved, I want to let you know that we had a very positive decision for a client from the New Jersey DEP commissioner on the definition of broker that is now standing in the statute. So please contact me if you would like to see a copy of that decision, and we're continuing to work on that. Beyond that specific sort of A901 regulatory realm in New Jersey, I would recommend that your business review its hazardous waste and landfill waste procedures just in general, and make sure it is using appropriate transport and disposal vendors, but also that it's containment of waste that, at your warehouses, at your office buildings, behind your stores, anywhere, is following all of the rules, hazardous waste control laws in your jurisdiction. An AG's office will not only just support the state DEP, in their enforcement actions, but they can also independently investigate and come after you about the disposal of hazardous waste. And they're very, very concerned about e-waste, electronic waste. Okay. I've been involved in this issue, not just in New Jersey, but also in California. And the AG's office would follow trash trucks, private trash trucks that a company would hire. Let's say you have a warehouse and you put things out in your dumpster. They will follow the truck that collects the items out of your dumpster, follow it to the landfill, serve a search subpoena on the landfill, and then go through your trash to see if you've disposed batteries, computer keyboards, anything like that. And then that could launch a very expensive investigation into your company. So everybody should be looking at those types of things. And if you're dealing in electronic waste, you also need to worry, as I said before, about privacy issues. I've also had a case previously in New Jersey that was about the disposal of electronic waste, and that electronic waste may have contained PII. So that's another thing that you really need to look at your electronic waste disposal processes and try to avoid having issues that will lead to a costly AG investigation and action. I'll also just mention ESG investing has become very hot topic among the AGs. They are not aligned on this issue. This is not a bipartisan issue. ESG investing, corporate decision-making that favors investments that would have a net positive environmental, social, or governance outcome. It's a very polarizing topic right now. Republican AGs are concerned that this type of investing is woke capitalism, and it prioritizes goals, social goals, over investor returns, and is harming the wider economy. On the other hand, Democratic AGs support generally this type of investing and see these multifaceted considerations actually delivering good financial gains. So we're going to keep tracking that issue to see where things lead. Okay, so now we come to the slide that I was hoping we would get to with 5 minutes. This is good. What should you do? So the first thing, consider engaging with AGs early and strategically. Sometimes there is a human thought that you should just stick your head in the sand and hide and wait for the regulator to come to you. And if they can't see me, they can't see me. Well, you should assume if it is a hot topic that regulators are already talking to one another, sharing information about particular topics. There are consumer advocacy groups who are talking to the AGs and telling them their side of the story. You want to make sure you tell your story before someone else tells it. So consider the value of educational briefings to help AGs understand your business and to understand why you do things the way you do them. New technology, for example, is something that always gets the eye of an AG's office. They are not technologists. They are not IT people. And so they will come to it without really understanding it. Anne-Marie mentioned telehealth, for example. It's a new technology. It's a new thing. Be a resource to the AG's office, and that could really help you avoid an expensive investigation or an action. And this is also where industry groups like the CIANJ and other associations really play a great role. They can go and talk to the AGs, and they can talk to other government officials to provide that type of insight. Your attorneys who attend these AG meetings also can serve in that role. But just, think about your own story, and that you want to tell your story before someone else tells a story about you that isn't accurate. Make sure your house is in order. So we've been talking about complaints. Do you track complaints? If you have someone who answers consumer calls, how are they recording complaints? Are they looking for trends? It is really a good business practice to track your complaints, understand what's causing them, and be proactive in resolving them. It sounds simple, but many companies just are focused so much on delivering good services and a good product that they don't take the time to do that sort of self-evaluation and see what actions they could take to improve. So we always recommend that. And your marketing too. Do that type of review of anything that could be considered marketing and advertising. Anne-Marie, do you want to talk about then what would happen? You've done all the positive things that you're trying to do, but an AG still comes and asks a question.
Yeah. You still get a call, or you get a letter of inquiry, or subpoena, or CID. So the first thing you do is, instead of hiding, we call and immediately we call the staffer. And one of the first questions we ask is, can you share with us what precipitated this? Sometimes we'll learn it's complaint driven. We got, hundreds of complaints from consumers. We really just want to find out what's going on. Can you help us resolve these complaints? Sometimes we learn it's from the front office. A new AG is in, they have priorities. They want to investigate everyone in the industry. I've been told, we are sending a subpoena to every single company in this industry. It's not just you, it's everyone. We are investigating the industry. That's really helpful information to know. So you want to engage, find out the source, because that will help you understand. You also want to find out, what is it they're trying to find out? A lot of times the way they're trying to find out information is the wrong way. So their subpoena is too broad, and the subpoena asks for things that don't exist, but it doesn't ask for things that exist that can help them answer the question. So unlike a typical civil litigation thing where you're trying to provide the minimum information, obstruct, be kind of too cute by half, with an AG, you're kind of trying to do the opposite. You want them to go away. So what is your question? What do you need to know to answer that question? Let us help you. We'll package it all up. We'll create you a spreadsheet. This answers all your questions. This is a lot easier for you to look at than send you a bunch of emails. The emails are not really going to tell you anything. A lot of times they're amenable to that. The other thing
can I just add in there, Anne-Marie? And what you're doing is, this is how you're telling your story at this point. So you're putting together all the things that would help tell the story about how the process works and is positive, reflects positively on your company. Even if they didn't ask for it, it helps you. Yeah.
And then, of course, part of this is just understanding the law of the state and the AG's powers in that state. So there's this, as a nerd, I love the nullum tempus certe regate principle, which means basically time does not run against the king. So in some states, there is no statute of limitations that runs against a state AG. You need to know that, because you might want to say, well, the subpoena goes back 10 years. And they can say, well, we can do that because we don't have the statute of limitations. So that's important to know. It's important to know what their open records laws are, whether the documents you send to them in response to the subpoena will be sent to third parties, your competitors, others. What protections can you get? One of the first things we do is we negotiate a confidentiality agreement to protect the document so that third parties can't get access to what we're producing for our clients. We look at prior settlements. We look to see, okay, what other people in this industry have been investigated and sued by this AG and for the similar conduct, and how much money did they pay? What did they agree to kind of evaluate that and see where we fit in. And then we, of course, always look for creative solutions. Sometimes it's truly about educating an office. They start an investigation because they think there's a violation of law. You walk them through, they meet with the business people, you have some PowerPoints to explain the business, and then you can see their brain clicking and they realize, okay, there's nothing to see here. This is not an antitrust issue. This is a different issue. So that's always satisfying when you can help to educate them as to why, your particular business is not only not violating the law, but maybe is providing consumers with a benefit that should be encouraged by the state. So that's one of the other things that we often do with AG offices.
Yeah, I know we're at time and a little over time, and we haven't left time for questions, but if anyone does have a question or wants to focus on a particular area that we've mentioned, or even one we haven't mentioned, Anne-Marie and I are available. You have our emails, you have our phone numbers. They will be in the handout that goes out. And we really welcome you to engage with us. Our firm puts out a weekly State AG report. That's a great way to kind of follow the trends. And so there's just lots of ways to engage with us. So, Kathy, I'll turn it back to you.
Well, Maria and Anne-Marie, thank you so much for such a great program with so much information to help out our members. We appreciate your time this morning, and we thank you for all of this that you've provided. And we'll be sending out, like we said, a packet to everybody in the recordings later on today. And again, thank you for taking the time this morning to be with us. Yeah, everyone have a great day.